Hi, this is Keith Davidson with Albertson and Davidson. In this video, I want to talk about a decedent's intent. So let's say you have a friend and you help that friend out throughout the last stages of their life, or maybe throughout their entire life, and that friend tells you, I want to leave you my estate because you've done so much for me. And maybe that friend doesn't have any children, doesn't have any close family, maybe they have some long lost cousins that they haven't seen in years. But then when that friend dies, you find out that the friend never created a will or never created a new will leaving the estate to you. What do? Can you go into court and tell the judge what the decedent's true intent was? And the answer is no, you can't, because in California, there's no such thing as an oral will. All wills must be in writing. That's one of the basic requirements of a valid will in California. And so that means if your friend never wrote anything down, never created a will, never did their own handwritten, what we call a holographic will, then you're not going to receive anything, most likely, from that estate. Now, I'm excluding from this video any claims for a contract to make a will and promises and that sort of thing. We have a lot of videos on that topic, which we'll link below so you can take a look at them. But for purposes of this video, we're really just focusing on, can you go into court and tell the court this is what the decedent wanted? And the answer to that is no. Now, if your friend had written down on a piece of paper, even in their own handwriting, and said, I want my estate to pass to my friend, and signed that and gave it to you, that would be a valid will. Or if your friend made a proper typewritten will that was signed and witnessed by two witnesses, that would also be a valid will, and you'd have rights to that. But if there's no writing, then there's no will. And if there's no will, then your friend's estate is either going to go to his or her heirs at law, meaning the long-lost cousins, or if there are no relatives, eventually it'll just go to the state of California, and you're going to be out in the cold. So that's some information about the harsh realities of what happens in California will law when somebody doesn't actually write down their intentions in a new will.